All right, so our first panel today is going to discuss approaches to advancing human rights. And to moderate this panel is this year's Henry T. King Award recipient, Karina Van Vliet. And I'm going to introduce Karina, and she will introduce her panelists, and then we'll get into the discussion. So Karina has served as the Chief Executive Officer of the Cleveland Council on World Affairs since January 2019. She leads the organization and its dedicated professionals to the execution of CCWA's mission, which is to inspire engagement in world affairs. And this mission certainly includes human rights and the promotion of human rights. Karina received her Bachelor of Arts in Political Science from Bowdoin College in Maine. She got her master's degree in International Relations from the National Political Science Institute in Paris. And she received her Master of Arts from the School of Advanced International Studies at Johns Hopkins, where our own Chris Sands is a professor. Her international education and experience has taken her all over the world, and she eventually wound up with a position at the United Nations, where she was a political affairs officer from 2006 to 2014. She covered Latin America, the Middle East, disarmament, women's peace and security issues, and also the Canada desk. As I mentioned again, she is this year's recipient of our Henry T. King Jr. Award for her role in always promoting our events and conferences, and for the community partnership that we've had year in and year out with the Cleveland Council on World Affairs. So, Karina?
Great. Well, good morning, everyone. How's everyone doing?
Good.
We can do better than that. Come on. Well, thank you, Steve, for the introduction. And I know that, as the Consul General said, we have an exciting program today that's going to really focus on the economics of human rights and what the implications are for trade and for businesses and the communities that are impacted by all of these issues. But what our job for this panel is this morning is to provide some broad framing on the issue, big, broad concept called human rights. And so for me, obviously, former United Nations Political Affairs Officer, when you say human rights, you know where my first thing I think of is Universal Declaration of Human Rights, adopted by the United Nations General Assembly on December 10th, 1948. Oh, and apparently, that is also the first thing that Dean Scharf thinks of when he thinks of human rights. And this is why last night, for those of us who were at the wonderful opening dinner, we all got our own Case Western Reserve University branded copy of the Universal Declaration. And I hope I did. I went home and I actually kind of browse through it again because it reminds me of all of the values we hold dear and what we, the international community, are trying to do to achieve and respect the dignity of all human beings. And the reason why Dean Scharf and I are thinking, and most of you too, of the Universal Declaration is probably two reasons. First, this is the document that spells out the basic political, civic, economic, cultural, and social rights that every single human being on this planet should be entitled to. Moreover, it forms the basis of the then subsequent 70-plus human rights treaties, instruments that have been signed at both the international and regional level since 1948. So this is where it all comes from. And second, bring this back to Canada and the United States, among the drafters of this document, of course, famously on the United States side, was First Lady Eleanor Roosevelt, but perhaps some of you didn't know that John Humphrey, who was at the time the director of the UN Secretariat's Division for Human Rights, was a Canadian, and the Canadian was the initial drafter of this document. So from day one, the United States and Canada have been intimately involved in the promotion and advocacy of human rights globally. But one thing that Dean Scharf also said in his remarks last night, and that I noted down, is that the implementation of human rights has been, and I quote, globally uneven. And even for the United States and Canada, while they have long been advocates of human rights on the global stage, when we look at their own human rights records, whether they're implementing both domestically or internationally, It's a bit of a mixed bag, which is what our panelists really wanted to talk about today. And so I think the Council General also alluded to this, where it gets really interesting on human rights is how this is implemented. And as a practitioner myself, what I saw at the United Nations is there's practically as many ways to interpret human rights law as there are member states, and that would be 193 for the record. So the devil is always in the details. And so here to shed some light on those nuances and perhaps identify where some of the devil is hiding in this, we have our three panelists, and I'll just in alphabetical order. First, Abidon Cover, who is Associate Dean for Academic Affairs, Professor of Law, and Director of the Institute for Global Security Law and Policy at Case Western Reserve University School of Law. His scholarship focuses on human rights, civil rights, and national security law. He has appeared in numerous news media, including New York Times, Washington Post, BBC, CNN, MSNBC, C-SPAN, Fox News, and Court TV. Professor Cover was a Fulbright Scholar from 2018 to 2019 in Nairobi, Kenya, where he taught international criminal law and legal theory at Strathmore Law School and researched refugee and security issues. Prior to his appointment at Case, Professor Cover taught at Seton Hall University, and in addition, he was the Gibbon Public Interest and Constitutional Law Fellow from 2007 to 2009. Professor Cover also served as senior counsel in Human Rights First Law and Security Program, where he researched and analyzed U.S. military and intelligence agencies' interrogation and detention policies and practice. And joining us remotely and hopefully behind me on the screen shortly, Dr. Sarah Gebremius, who is the Castles Chair in Mining Law and Finance and an assistant professor at the Faculty of Law at Western University. And she's joining us remotely today due to a last-minute family emergency. So we're very grateful to her for making the time to join us remotely despite a last-minute emergency. So Sarah, I hope you can, oh, there you are. Welcome. So her scholarship focuses on mining law and governance, law and development, transnational law, and business and human rights, with a particular focus on the interest of Indigenous people and mining-affected communities. She is a principal co-investigator of the Canada Climate Law Initiative, which is a joint project founded by the University of British Columbia and York University. She is also a board member with the Justice and Corporate Accountability Project, which is a nonprofit that provides legal support to mining-affected communities in Latin America and Africa. Dr. Gebremius is currently the principal investigator of a project funded by the Social Science and Humanities Research Council, and that is examining how two Canadian mining conflicts in Tanzania and Zambia have contributed to institutional transformation in both countries. And finally, Brian Gran, who is a professor of law at Case Western Reserve University School of Law. His scholarship looks at how to use rights as a means by which to improve well-being. His research program investigates what institutions and structures facilitate and obstruct agency when it comes to using rights as a way to improve outcomes, reduce disparities, and advance social policies. Much of his work is interdisciplinary, drawing on sociology, law, and public policy research. Of note, he served as a Jefferson Science Fellow in 2020-2021 with the Bureau of the U.S. State Department's Undersecretary for Civilian Security, Democracy, and Human Rights. Wow, that was a lot. I would love a warm round of applause for our panelists. And so back to this question that Dean Scharf teased out last night. It's like, well, okay, human rights, we all sort of know what it is. And both the United States and Canada have long promoted and advanced human rights. But what does that look like in practice? And where has the implementation been uneven? And perhaps we'll start with a U.S. perspective from you, Professor Cover.
Stand up.
As you wish.
Okay. All right. Good morning. Thank you so much for that introduction. I look forward to this conversation with the panelists and look forward to the rest of the day's illumination on these important issues. So I want to say the United States considers the promotion of human rights a major foreign policy concern. President Biden has recently stated the United States is leading by the power of our example. demonstrating that our commitment to human rights begins here at home. He's pointed to the U.S. return to the Human Rights Council and other multilateral steps, a vital course correction from the unilateralist Trump administration. But while there are doubtless positive steps, there are significant acts and omissions that call into question the domestic commitment. The U.S. failure to adopt international human rights obligations for itself, while at times taking a leading role in advancing that cause elsewhere, ultimately impoverishes both the United States and the rest of the world's commitment to and compliance with international human rights. The continued lack of fidelity to human rights, particularly domestically, calls to mind the great Professor Lewis Henkin's warning 3 decades ago of the ghost of John Bricker. Senator John Bricker was a senator from this very state, Ohio. Animated by states' rights sentiments and fears of international law, presidential power, and opposition to the civil rights movement, Senator Bricker sought to amend the United States Constitution over a series of years, in particular the treaty power, so that treaties would be effective only through legislation which would be valid in the absence of a treaty. Now, these amendment efforts were ultimately pushed back, but the price included President Eisenhower's promise not to accede to human rights treaties. The legacy of that compromise, that is, Senator Bricker's ghost, as Professor Henkin phrased it, may still be limiting the advancements of human rights, unable to reconcile sovereignty with subjecting the state to its human rights obligations. I want to talk briefly today about at least 5 ways in which the United States not only fails to advance human rights, but undermines these critical protections and obligations. First, the U.S. failure to ratify human rights treaties. Karina referred to the numerous human rights treaties that are out there. Exactly 30 years ago, 1994, the United States, it was a wonderful moment, ratified the Convention Against Torture. It ratified the International Convention on the Elimination of All Forms of Racial Discrimination. But along with those two, the only other major U.S. human rights treaty that the United States has ratified is the International Covenant on Civil and Political Rights, just 2 years earlier in 1992. 3 human rights treaties. That's a sad record for a nation that purports to lead in human rights. As at least one report has noted, not ratifying undermines the credibility of the United States when it advocates for foreign governments to adhere to international human rights obligations. Now, I have focused a lot less on Canada, but I would say Canada, by contrast, has ratified 7 core human rights treaties. Second, in numerous instances, the United States has attached reservations, understandings, and declarations to these 3 ratified human rights treaties, limiting the effect and judicial enforceability of these binding instruments. Invoking the Constitution, concerns about federalism, the United States has frequently applied constraining interpretations, weakening, for example, the strictures on cruel, inhuman, or degrading treatment or punishment, legal positions that had real-world impact on the U.S. interrogation policy after 9/11 and led to widespread abuses worldwide. In some instances, these reservations would seem to violate the very customary international law tenets of treaty interpretation because they're incompatible with the object and purpose of these treaties. Third, the United States has refused to subject itself to the jurisdiction of important international courts that adjudicate human rights and humanitarian law. The United States is not a party to the Rome Statute, the International Criminal Court, one of only 7 states. That court is intended as a bulwark against impunity and has jurisdiction over war crimes, crimes against humanity, genocide, and aggression. In the wake of the Russian invasion of Ukraine, the United States has laudably cooperated in sharing information with the ICC. But while laudable for its support of accountability mechanisms, the U.S. is inevitably susceptible to charges of opportunism and geopolitics that undermine its human rights commitment. The U.S. relationship to the International Court of Justice raises similar concerns. Dating back to the court's adverse decision almost 40 years ago in the military and paramilitary activities case relating to Nicaragua, the United States withdrew its declaration recognizing the court's compulsory jurisdiction. And the U.S. has not recognized ICJ jurisdiction under any of its human rights treaties that it has ratified. And even where the U.S. executive has at times shown a willingness to comply with ICJ rulings, individual states, such as Texas, with the blessing of the U.S. Supreme Court, have ignored such rulings relating to consular access in the death penalty context. Finally, U.S. officials' recent denunciation of ICJ proceedings initiated by South Africa against Israel concerning claims of genocide undermine that institution structured to adjudicate human rights disputes. Moreover, the U.S. failure to criticize Israel for its actions in Gaza may be a missed opportunity because, as Rochelle Turman has recently argued, human rights pressure works best when they come from allies rather than adversaries. Fourth, the United States regards all of its human rights treaties that it has ratified to be non-self-executing. Thus, without implementing legislation by Congress, requiring both houses, though properly consented to by 2/3 of the Senate, such a treaty is not judicially enforceable. The International Covenant on Civil and Political Rights, which has not had implementing legislation, is then effectively a dead letter, unenforceable in U.S. courts. Fifth, the U.S. Supreme Court is not interested in human rights, let alone advancing them. 2 years ago, under questioning at her confirmation hearing, now Justice Ketanji Brown Jackson stated that it would not be appropriate to look to international law to interpret constitutional rights. She said, "There are very, very few cases in which international law plays any role, and certainly not in interpreting the Constitution." In answering, she contrasted significantly with her predecessor, Justice Stephen Breyer, and for whom she had clerked, who was perhaps the court's most ardent advocate of looking to international law and human rights treaties. Justice Jackson's remarks, whether sincerely felt or simply politically astute, demonstrate how far the court has departed from its human rights-oriented constitutional rulings of just 2 decades ago. Then, over a short period, the court leaned on foreign law and human rights instruments in ruling that the Constitution, for example, prohibited executing people who committed crimes as minors or were mentally disabled, and when the court prohibited criminalizing intimate same-sex conduct. It is hard to conceive of the current court, which has privileged federalism concerns over international commitments in its decisions, issuing such rulings today and in the short term or long term. The court has also beaten back a retreat from its 20-year-old recognition of a cause of action for customary international law violations. From 1980 through at least 2004, the Alien Tort Statute had been seen as a critical vehicle for non-citizens, people the world over, seeking judicial relief in U.S. courts for human rights violations perpetrated in countries where they could not secure civil accountability. But in 3 successive rulings, the Supreme Court curtailed the law's extraterritorial scope and has prohibited its application to foreign corporations. If we might briefly contrast again with Canada, just about 3 years ago, the Supreme Court held recently that Eritrean plaintiffs might sue a Canadian company in Canadian court for human rights violations committed abroad. So Lou Henkin would still be disappointed. The ghost of John Bricker does indeed still hover over the U.S. imperfect commitment to human rights. Indeed, there's a through line, I think, that we can see with the populist and isolationist appeal of Trumpism. If the United States is truly serious about advancing human rights, it must lead by example with an approach that looks and acts not only outward, but inward. Thank you.
Well, thank you so much, Avi. That was wonderful, and I'm sure there'll be lots of questions for you, no doubt, in the Q&A on all of those points. What I thought we would do is first hear from all 3 of our panelists, and then have a bit of a moderate conversation and open up for all of your questions. So I'm sure, especially the students, probably have burning questions on everything that was just said. But I'd like to turn out from a slightly different perspective on Canada, from Sarah, who's joining us virtually, and just for her to talk a bit more about how she sees Canada implementing human rights abroad, particularly when it comes to commercial and business interest overseas. So, Sarah, over to you.
Hi, good morning, everyone. I hope you can hear me all right in the room. Great. So I first want to start off by thanking the conference organizers for the invitation and for quickly helping me pivot to remote participation. I wish I could have been there in person and hope to attend a future edition of the conference very soon. I'd like to begin my remarks by acknowledging that I am joining you from the traditional lands of the Anishinaabeg, Haudenosaunee, Lenapewauk, and Attawandaron peoples on lands connected with the London Township and Sombra Treaties of 1796 and the Dish with One Spoon Covenant Wampum. With this, I acknowledge that I respect the long-standing relationships that Indigenous nations have to this land, as they are the original caretakers. I also acknowledge historical and ongoing injustices that Indigenous peoples endure in Canada, and I accept responsibility as an academic at a public institution to contribute toward revealing and correcting miseducation, as well as renewing respectful relationships with Indigenous communities through my teaching, research, and community service. And I make this acknowledgement for two reasons. First, as I mentioned, to signal my responsibility, in particular, my responsibility as a mining law scholar teaching colonial Canadian laws on Indigenous lands, where so much of Canadian mining occurs. And secondly, I think it neatly sets the stage for my comments, which may preview some of this panel's discussion and this afternoon's panel on Indigenous reconciliation and development. So as Avi mentioned, throughout his remarks, Canada has been a global leader in human rights. Yet its record as a country whose economy depends heavily on resource extraction, like mining at home and abroad, reveals its mixed record on human rights. So Canada has been a global human rights leader in the ways that it played a central role in the drafting of the Universal Declaration of Human Rights, as Karina mentioned. Canada is a party to major human rights treaties, including the Convention on the Prevention and Punishment of the Crime of Genocide, the International Covenant on the Elimination of All Forms of Racial Discrimination, the International Covenant on Economic, Social, and Cultural Rights, the International Covenant on Civil and Political Rights, the Convention Against Torture, the Convention on the Rights of the Child, and even more recently, the Convention on the Rights of Persons with Disabilities. And Canada has actually attempted to implement domestically its obligations under international human rights law through domestic human rights measures. And most notably, that has been done through the Canadian Charter of Rights and Freedoms, which in effect has constitutionalized several of Canada's internationally recognized human rights. And what Canada did when the Charter was adopted, it also entrenched the rights of Aboriginal peoples, as the Constitution refers to them, through a provision called Section 35 of the Constitution Act, which recognizes the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada and hereby recognized and affirmed those rights. Yet even with these constitutional protections, Canada's role as a global leader does not necessarily align with its domestic and international track record, especially when we take a closer look at Canada's role as a global leader in mining. So let's first consider Canada's relationship with Indigenous peoples and mining. As I mentioned, mining largely takes place in Canada on Indigenous lands. And despite Section 35, the recognition and advancement of Aboriginal and treaty rights has largely occurred through the courts, where the Crown or Canadian government has resisted in many respects the attempt of Indigenous peoples across Canada to protect their Aboriginal and treaty rights. Now, one way in which Canada's relationship with Indigenous peoples could be course corrected is through the United Nations Declaration on the Rights of Indigenous Peoples, or UNDRIP, an international human rights instrument that was adopted by the United Nations General Assembly in 2007, but which Canada initially resisted. And it took several years for Canada to eventually sort of sign on to UNDRIP. More recently, the Canadian government committed to aligning its laws with UNDRIP by passing domestic legislation, along with one province, the province of British Columbia, in separate legislation. So this potentially suggests that something like Section 35 may not be enough to actually advance Indigenous rights across Canada. However, how this could play out may still limit the potential of an international human rights instrument like UNDRIP to advance the rights of Indigenous peoples across Canada. And that's because, given its role as a separate piece of legislation whose status is still very unclear, so far courts in Canada have actually indicated that the legislation and perhaps UNDRIP are just merely used as interpretive aids to already sort of interpret Indigenous rights within Canada, as opposed to actually requiring that the Canadian government or various provinces actually have separate obligations and stronger obligations to advancing the rights of Indigenous peoples. One such example, as it relates to mining in particular, is a recent case that took place in British Columbia, where two First Nations actually challenged the province's free entry system as it relates to mining. So anyone in British Columbia could essentially stake a claim without actually consulting with the Indigenous peoples that reside on that territory. And so these two First Nations challenged the legislation and saying that, given that British Columbia had recently adopted UNDRIP legislation, that not only did the legislation that permitted the free entry system violate Section 35 of the Constitution, but it also was a violation of the domestic UNDRIP legislation. And in its decision, the court held that, in fact, the mining free entry system was only a violation of Section 35 and the duties that sort of arise from there, as opposed to sort of returning to UNDRIP and saying that UNDRIP was instead only an interpretive aid. So then it, again, sort of raises the question and begs the question whether, with Canada sort of signing on to and agreeing to significant international human rights instruments like UNDRIP, whether in fact that would have full domestic implementation, either through legislation or through the courts. Internationally, Canada has often used state resources to protect Canadian mining companies that have been accused of human rights violations. And Canada has been criticized for its unwillingness to adequately regulate the activities of Canadian mining companies operating abroad. And so instead, Canada has relied on issuing policy recommendations, the most recent being its responsible business conduct abroad strategy. And this does not exclude, of course, some of the legislation that Mr. Bird referred to earlier around sort of supply chains and the Modern Slavery Act that attempts to regulate human rights in relation to supply chains and the use of forced labor. But there are a number of instances where Canadian extractive companies and mining companies in particular have been accused of serious human rights violations that do not fall under the mandate of that legislation. And so criticism of Canada's governance gap contributed to the creation of a non-judicial state-based grievance mechanism, the Canadian Ombudsperson for Responsible Enterprise, to hear complaints against Canadian extractives and garment companies that have committed serious human rights violations. And this was announced in January 2018, and the Ombudsperson has been receiving complaints and hearing complaints over the last few years. Unfortunately, the core, as the Ombudsperson's office is known as, has lacked teeth and continues to lack teeth since its creation. And there have been efforts by a private member of parliament to significantly reform and empower the core. A bill was passed in March of 2022, and it has actually not passed first reading. So again, an indication of how seriously the Canadian government is willing to hear and take critiques of its human rights record as it relates to Canadian mining companies. The Corps did recently conclude its first investigation into allegations against a Canadian mining company operating in China, Dynasty Gold, for the alleged use of Uyghur slave labor. And they made several recommendations to the Minister of International Trade and the company, and how the Minister of Trade and the company respond could empower the Corps' mission, or it could jeopardize it before it even gets too far off the ground if they do not adhere to the recommendations, thus further limiting Canada's credibility in the enforcement of mining and human rights. So thank you, and I look forward to the conversation that we'll have as a panel and to our conversations throughout the day. Thank you.
Thank you so much, Sarah. And then sort of broadening out the lens a tiny bit with our interdisciplinary specialist on the panel, Brian, if you could sort of, and I think you have a PowerPoint.
Right.
Great.
So I'm going to stand up there.
Great.
Thank you. Will you folks move it for me? Cool. Thanks. Okay. Good morning. Great to see you and be with you today. My primary appointment here at Case Western is I'm a sociologist. I have the great fortune to have a secondary appointment with the law school. Michael, Jessica, and other folks, including Avi and other people in the faculty, have been very supportive of my work over the years, for which I'm really grateful. So what I'm going to talk about today is a little different. I'm going to talk about do human rights produce well-being and other desired outcomes, and then what else is necessary for human rights to produce these outcomes. And my perspective comes from having opportunities to work with the United Nations on thinking about indicators of human rights, working with an organization here in the United States called the American Association for the Advancement of Science. They published the journal Science on indicators of the human rights of science. And then I also, as was mentioned, I was on leave with the U.S. Department of State and continue to consult the State Department, and some of the work I do for them has to do with indicators of human rights. To follow on what Avi said, one of the questions I work on is, in addition to just trying to understand how and whether human rights matter, the questions that sometimes people ask, how would ratification of one of these treaties change what's going on in the United States? So when we think about the outcomes human rights are supposed to produce, scholars, government officials, UN officials, leaders of human rights, watchdogs, assert that human rights are supposed to produce specific results, promoting government accountability, for example, promoting well-being and preventing harm, and reducing discrimination while promoting participation. Indicators of human rights try to measure those kinds of things. And one of the predominant approaches, I would say, to thinking about how to measure human rights actually comes from work on health policy. There was a UN Special Rapporteur, Paul Hunt, who worked on the right to health, who took this concept of structure, process, and outcomes to think about the right to health. And his ideas, I think, are embraced by many people at the UN and others who try to study human rights indicators. So scholars working across disciplines, interdisciplinary work, UN officials, and other experts work on these human rights indicators using the structure, process, and outcome. A structure indicator, for example, measures the degree to which a national government has incorporated treaty components into national law, for example. A process indicator measures the degree to which a national government has established processes to implement those rights so that individuals can exercise those rights. And then an outcome indicator measures the degree to which an individual can enjoy a right. So I want to just present some information that are examples, and they're examples of a few things. So this is one example, and one of the first things you probably see here is where you're thinking, his lowest grade in school must have been art class, and you would be right. It's true. But this is one example of some of the indicators I'm working on with a team of people. And this looks at incorporation of the UN Convention on the Rights of the Child into national law. So the idea is that just because a government has ratified doesn't mean, as Avi and our other speaker said, doesn't mean it necessarily happens. And so this is just a measure of whether a government has incorporated the UN Convention on the Rights of the Child into their national law. And you can see this is a rough indicator. It goes 0, 0.5, and 1. A 0 means not at all. A 1 means yes. And then a 0.5 means partial. And there are a lot of other ways to measure this. But one of the challenges of doing this kind of work is access to data for all these 193 countries. But this is an example of structure to a degree to which government has incorporated the convention into national law. This is an example of process when we look at public education expenditure as GDP. So we would, in some ways, think that if a government has ratified the UN Convention on the Rights of the Child, for example, or one of the other conventions, that they would then turn around and spend money on education, building schools, improving schools, hiring teachers, buying textbooks, getting resources to students. But we know that when it comes to expenditures on public education, it really varies across the world. The range here is from 0.27 of GDP, which is Somalia for this particular year, to 13.6, which is Kiribati. And then this is usually where we end up often when we talk about indicators, but the point I'm trying to make is it's important to think about structure, process, and then outcomes. This is a measure from PISA. You may know this. This is population level results that reflect an individual or a child's right to education. So PISA, which is supported by the OECD, has developed this database on comparative information on mathematical performance and science performance or science literacy of students in upper grades, the kinds of kids who are near the end of their compulsory schooling. And you can see there are fairly big differences that if we look at some of the other maps, the two previous maps don't necessarily line up. Does that make sense? Okay. As I mentioned, people who look at these indicators are trying to capture different parts of human rights. And often we want to know about whether discrimination is taking place. And this is just an example of a measure that looks at primary education, paying attention to the percent of students who are female. This requires disaggregating data, which is very challenging because many countries do not do that. And this is one of the areas where the United States, Canada, other countries have really pushed for governments to collect this kind of information. And I'll tell you, I've always been very surprised by the lack of data, which makes it very hard to determine whether how these conventions and how human rights matter. And this is particularly true around education. So, as I wind up here, what do indicators indicate? So what's the point? The governments of Canada and the United States subscribe to the view that human rights are important to life, together, living together, and as the bigger picture, our relationships with other countries. Indicators not only shed light on how countries are doing, but how can be used to determine whether human rights are important to living together. They can be used as tools to advocate when it comes to bilateral, multilateral treaties, other kinds of efforts that are not so formal, in asking other governments to try to ratify as well as implement human rights. So when we look at these indicators, we see, and you'll find this is true for the other human rights treaties, despite near universal ratification of the UN Convention on the Rights of the Child, as you know, the United States is the only member party that has not. We find structural variation across countries. National commitment through budget allocation also varies. It's true for other processes. And then outcomes differ when it comes to education. This is true in other kinds of treaties. So my bottom line is the indicators are very useful for measuring whether human rights matter and what needs to be done. They're not the end-all, be-all, I will say, but I would argue that they are valuable tools. Thank you.
Thank you, Brian. So I hope what the takeaway from these initial presentations for our three fantastic panelists is you take away the same thing that I do, which is reinforcing the notion that these are really complicated issues to unpack. Because I think, as Avi pointed out broadly, while the United States is out front on the global stage rhetorically advancing human rights, there were those 5 ways he pointed that in practice it is actually undermining some of the very things that it purports to advance. And then even when these international instruments are ratified, as Brian pointed out, there's huge variation in how these are actually implemented process-wise. And at the end of the day, if we're looking at how individuals in Canada and the United States and globally actually benefit from human rights or not, that becomes, you know, the result of so many other factors. And I think Sarah did a wonderful job of showing how in Canada some of these things, you know, getting granular on how these things are implemented. So I think the first question I'd like to hear more of your thoughts on, and perhaps starting with that phrase used, Avi, about the perceptions of opportunism of human rights. You know, when is human rights used for political reasons, particularly by the United States on the global stage? And I'm wondering if you have some thoughts on that, Sarah, if you have any thoughts, and Brian, if you have any thoughts.
Yeah, I mean, you know, I think there's an inevitable, you know, however you want to frame it, right? Those in glass houses shouldn't throw stones, you know, decrying certain things as hypocritical if, you know, you do make, and certainly we can point to the Declaration of Human Rights legacy. You can certainly point to the advent of the 1970s under the Carter administration, where human rights really became a focal point of foreign policy. That it's hard, right, to shake your fist at other state actors when you aren't, for example, ratifying these human rights treaties. Now, I think Brian's research, raises some really illuminating issues, and at times the United States has at least one of its defenses or arguments for not ratifying treaties is sometimes precisely that, right? It's sort of a notion of we can't, based on our constitutional structure, based on federalism, based on certain core things, either ratify that treaty, or if we're going to, we have to reserve it because we don't want to be hypocrites. Now, that is indeed one position. The other would be, and I think the conceit of international human rights law is that it actually should compel states to at times change their laws, change their policies, change their practices. And so, at times, I think it's a fair and difficult discussion to have, but I think at times the United States is being some political forces are being a little too clever by half.
But perhaps the argument that sort of what your analysis is looking at, it's like, yes, perhaps the United States hasn't ratified and there's all reasons and, respect for our Constitution, et cetera. But at the end of the day, if you're looking at the benefit, like individual Americans, we actually benefit for a high degree of human rights. So just your thoughts on that, and Brian, your thoughts as well.
Do you want
The outcomes piece.
Sure.
Yeah, I would say, thank you. I work on a variety of topics, but I don't want to just stick with the children's rights because I know that's not really what we're focusing on here. But there is a group, multiple groups in the United States, but there is one main group in the United States that every so often thinks now's our chance to ratify the UN Convention, and they get ready to make those arguments. And one of the aspects, because one of the arguments against the convention is it's going to mess everything up. Parents' rights will go in decline. All these other problems. And so what we have done through using the indicators is demonstrate, when we look at the different articles of the convention, just how far off is the United States. And in many ways, we're not that far off. There's some areas where we really are far off. But that's one of the points to make. And then you can flip that around, and when we look at other countries and say, you're ratified, but it looks like smoke and mirrors. And that can be a really important lesson to look at, including in the State Department. The other thing I would say, this information is really valuable to human rights watchdogs. For them to come out and argue outside of what the United States government might say. Another organization that can say, the data says you're not doing very well here. And so that's also in the back of our minds when we work on these indicators of making this information publicly available, accessible, and keeping the information up to date, which is really difficult. The other thing I'll say is sometimes I think this information can point to difficulties ahead, where you can see changes over time that a government or a country has declined in a certain area when it comes to human rights, and it can raise concerns about what might happen in the future.
Sarah, I'm going to try to bring you in on this conversation, and wondering what your thoughts are. We've talked a lot about the United States, but Canada, and where is Canada sort of living up to its international obligations, and where do you feel there's a lot of opportunism that, for political reasons, some of the obligations get, what's the word I'm looking for? Not implemented in full.
I think overall, I mean, Canada does do a good job, right? It is a party to a lot of the major, like the core international human rights instruments. And so domestically, I mean, I think most of Canada's population does sort of benefit from a lot of the, especially civil and political rights. The courts in Canada have done a really excellent job with using the Canadian Charter of Rights and Freedoms as the foundation and bringing in these international instruments as interpretive aids. Of course, the domestic situation for a lot of Indigenous communities is very different, and so I think there it presents a challenge. And I mean, I don't want to suggest that it's necessarily opportunism, but I think the main area where sort of Canada is significantly falling short is in relation to the enforcement and implementation of human rights, like business and human rights obligations. And now, as I didn't make it clear in my remarks, but I think many of you in the room will probably understand that there are sort of very limited number of international business and human rights instruments that have been sort of formally concretized internationally. Like we have some norms with the UN guiding principles, the OECD guidelines, but we don't have a business and human rights treaty, for example. And so it's a matter, I think, of Canada and perhaps in the United States and other countries sort of being very creative and thinking about ways that they could sort of fill in those gaps if they want to. Instead, they've attempted to fill in the gaps in ways that I think are achievable, like through the Modern Slavery Act, and through looking at issues around due diligence and supply chains. And sometimes I have to wonder if those are being done for political aims as well, because oftentimes in these discussions around how we actually regulate business, it's a matter of thinking about ways in which we can regulate business in order to protect our domestic business interests while offsetting them against sort of foreign powers, especially countries like China. I mean, it's easy to understand why the complaints that the Canadian Ombudsperson on Responsible Enterprise has largely received thus far have targeted Canadian companies that have been accused of, operating in with the use of forced labor in Xinjiang. So it seems at times that it is a lot of political opportunism, though. I mean, I can't deny that at the same time that, as Canadians, we do enjoy a lot of the international human rights that have been domesticated for the large part.
I want to make sure we reserve about 20 minutes for all of your questions, because we covered a lot, and again, these are tricky issues and sometimes difficult to address. But so this will be my last question. But Sarah, piggybacking on what you said about this issue of domestication, I know there are a lot of lawyers and aspiring lawyers in this audience, and so I'm wondering. And you gave that lovely the example of what happened in British Columbia, where when you said it was more international human rights law was more used as an interpretive aid. And I was wondering if you could give us more details about examples in Canada where international human rights covenants or treaties have been successfully domesticated through legally, and other examples of where you feel like it hasn't and why. And same question then to Avi and Brian.
Yeah, I mean, as I said, through the Canadian Charter of Rights and Freedoms, a lot of sort of Canada has taken the position that it has domesticated a lot of its international human rights obligations. And so it really has fallen on the Canadian courts to actually make that determination and in ways have done a really good job of looking to international human rights instruments to actually enforce Canadian Charter rights. And so there are a number of cases where, for example, the Convention on the Rights of the Child, for example, has been used to actually ensure that the rights of, let's say, for example, a parent in a domestic refugee case against the government who may have had, children who were born in Canada actually have their rights of the children considered using the Convention on the Rights of the Child as sort of more than an interpretive aid, but ensuring that Canada's domestic obligations are in fact aligned with the international instruments in which it says, in which it is a party to. And the case that Avi referred to earlier in relation to where the Supreme Court of Canada said that a group of Eritrean plaintiffs could sue a Canadian mining companies, the court there relied on the way in which customary international law is domesticated within Canadian law. And because customary international law is automatically a part of the Canadian common law, and the prohibition against slave labor, cruel, inhumane, and degrading treatment is customary international law, the Supreme Court said that is automatically a part of Canadian law. So we have seen the courts sort of be very robust in using international human rights law to enforce and domesticate that law. And then there are gaps in other areas, as I mentioned that case in British Columbia, where the United Nations Declaration on the Rights of Indigenous Peoples is being used more as an interpretive aid. And that's because the court, I guess, in their opinion, felt the provisions that are currently in place in Canada's Constitution are sufficient to protect the rights of Indigenous peoples. But I think what UNDRIP provides is sort of more elevated protection of those rights. And so Canada right now is in this very, I think, sort of critical and interesting crossroads where we do have domestic protections, which the courts say are sufficient in some ways, but Indigenous peoples are saying that they're not enough. And I mean, we could probably dedicate, the whole day to a discussion of that. And I'm sure this afternoon's panel and the speaker who's bringing the Canadian perspective will probably shine more light on that.
Avi and Brian, any thoughts on the U.S.?
Sure. I mean, so first on one point, I mean, in some instances, may well be. I mean, the United States argument, for example, for not viewing the International Covenant on Civil and Political Rights as self-executing, right, is they largely take the position that we're already doing it, right? And there's a level of truth to that, and certainly the civil and political rights that are vouchsafed by the U.S. Constitution and a variety of laws, and so they certainly have a strong civil and political rights tradition. What is lost, though, by not rendering such a thing self-executing is courts are less likely to look to other interpretations of those rights. Certainly any dispute mechanism is then abdicated as a mechanism, and you're simply not part of within that tradition. But there certainly are some protections that are guaranteed by the United States. They have, in particular ways, implemented portions of agreements. So the Convention Against Torture, for example, the United States, and partly does explain the memos from 22 years ago that sort of it tried to evade the strictures of torture. It was partly because the United States had actually adopted legislation implementing the Torture Convention that prohibits the use of torture even outside of the U.S. territory, indeed must be criminalized, right? That's an example of a positive, albeit then later evasive legal techniques by the government. Another example, more recent in time, is that the United States has adopted, pursuant to the Geneva Conventions, its obligations to adopt universal jurisdiction for war crimes. Again, that might be seen as somewhat opportunistic since it seems to come in time with the Russian invasion of Ukraine, but indeed, even if long awaited, certainly came through. One final point, it's a little bit different, and I'd be curious just even Brian's thoughts, but, is that while ratification might not always then mean certainly perfect compliance with human rights obligations, there's an important value in adopting these laws. And I think there is norm generation that comes with it. We don't talk about, for example, in the United States, 49 of 50 states, Mississippi accepted, have constitutions guaranteeing the right to an education. Right? Education is, albeit not funded perfectly and not provided perfectly. Right? We don't decry the inadequacy of the laws of education or say maybe we shouldn't have constitutional amendments that provide as such. It still does require governments to do the work. And I think that's what Brian's research really does show.
Well, bearing in mind the time, partly very interested in what Sarah and Avi have said. Anthropologists have done really interesting work about what's going on nationally and then actually what happens locally and people's experiences. And so this is spurred in some people. I'm working on an international survey of human rights that goes out and asks people, what are your experiences, what are your opinions with human rights? And the degree to which people actually, human rights matter, or they even think about them in their day-to-day lives. And so that's one of the aspects we're also trying to get at to try to understand.
Great. What are your questions in this broad conversation?
Is there a microphone?
Oh, there. There's Q&A mics on either side.
Great.
Thank you.
Ah, yes, failed to point out, sorry, moderator, microphone here and microphone over there.
Thank you. Is this on?
Yes.
Okay, great. My question is for Sarah Gerbermus at Western University in her work with respect to human rights and mining corporations. It is a big issue with respect to indigenous people globally. And it's the juxtaposition of human rights and international trade. And that's kind of the whole conference thing here, but I want to scope this out a little bit. Generally, trade is all about finding the best price for the quality of the product and moving the material, product or service internationally by corporations. Corporations are concerned about shareholder return on investment, about price, and about maximizing profit. Corporations are not humans and therefore do not have human rights. How do nation states incentivize corporations to uphold human rights through their values and corporate decisions that they make? How do you incentivize the corporation to make the best, to say that it's in their best interest to do something that's not innately part of their DNA to uphold human rights in their international dealings?
Yeah. Karina, did you want to take a few questions first, or just I can go ahead and answer?
I think that was very much pointed directed to you, Sarah, and I think we'd love your answers.
Sure. I mean, I think that thank you for that question, and that's certainly, I think, the sort of the crux of the challenge of being able to balance business interests and human rights. And I think the question, I mean, for me, the approach that I take is not that corporations should be incentivized. Instead, they should be regulated, and those regulations should be enforced. Corporations are legal fictions, right? They're creatures of statute, and so there is legislation in place that could easily be reformed. Like corporate law could be reformed to ensure that corporations adhere to and respect. I'd say even go further than just respect human rights as called for in the UN Guiding Principles, but actually adhere to them and do not in any way attempt to violate them. And there have been, I mean, especially when it comes to, for example, issues around environment, social, and governance, ESG concerns that corporate boards and financial companies are becoming more attentive to. There are these mechanisms in which the case for corporations to respect human rights and say that it is in the best interests of these companies to do so is really moving forward. And I think where the state needs to get involved is ensuring that sort of the regulations and the laws that are in place are up to speed and are actually perhaps even more forward-looking than the ways in which we have these other sort of very, very soft law instruments in place to do so instead.
Go ahead.
Hi, so we have a question from one of our online participants, so I'll read it here, and this is to Avi. To what extent did the Supreme Court rely on foreign or international law in the cases that generated the controversy that you mentioned? Would those cases have come out differently if the court did not refer to foreign or international law?
I mean, it's a good question whether it is determinative or not. I think some could certainly argue that it was dicta in some instances. So these are opinions largely written by Justice Kennedy addressing same-sex conduct and the execution of individuals. But you have, for example, in relating to the death penalty, both for minors and mentally disabled, a canvassing of foreign law and the practices of other states, right, taking into account those practices. And that's part of, when we basic customary international law, sort of customary international law 101. We look at state practice and we look at whether states are doing these things out of a sense of legal obligation. I guess whether it was determinative or not, I mean, I think what is worrisome to me in terms of, I think, the current majority of the court, and probably most famously then Justice Scalia decrying any attribution or citation of these, is a resistance to even considering, to even having a dialogue, right? I mean, that's what sort of Justice Breyer, I think, most famously thought and argued was, we are a community of nations, an ever smaller globalized world. We should be looking at other ideas. We should take them into account. And notwithstanding concerns about sovereignty, the views and practices of other nations do inform what is just and what should be the law. So I don't think we can say whether it was outcome determinative, but I do think it's a line of law, a body of law, that we are poorer for not having courts now and the justices look to any longer.
Sanjeev.
Okay. I actually had two questions. The first question is there a concept of suspension of human rights in the international law concept of suspension of human rights when there is a national emergency? And I think it's probably becoming most apparent in, for example, the country of El Salvador, where there was basically lawlessness, and the country has turned to President Bukele, who is, I think, by all sort of conventional measurements, suspended human rights in a lot of the actions he's taken in El Salvador. You're also seeing some of that now in Ecuador as well with their lawlessness. So that's one concept I'd like to sort of hear what the panelists think about. And the second is the concept of free speech is human rights. I think that's becoming more and more of a concern in light of the social media and fake news and the ability of governments to limit free speech because of the power of social media and its potential impact on democracy. So I'd be interested in hearing what the panelists think of that concept as well.
I think the concept is called derogation of human rights. And so there's really interesting scholarship out there. So the COVID pandemic actually provided an unusual opportunity to study derogation across societies and over time, because many governments suspended human rights during the pandemic, the right to travel, the right to assemble, other kinds of rights. So there's, up until then, research that primarily focused on particular instances, countries that suspended human rights, certain kinds of public emergencies like natural disasters, as well as coup attempts, things like that. But the pandemic is this really interesting research. There's a great database through an institute at the University of Oxford that has data day to day about suspension of human rights having to do with the pandemic. And it kind of goes back to this idea that there's degrees. So they look at different qualities, different rights, and then different qualities of these rights to study what the different governments did, and then, of course, in a sense, did it work? Did it prevent transmission of COVID and reduce the number of deaths? So, I'll stop there.
Yeah, I guess I'd only add to that. I mean, there are, however, pretty specific procedures by which a state would derogate in terms of process-oriented, in terms of declaring such. Got to meet standards of necessity and proportionality. And there are certain rights for which you cannot suspend. So death, cruel, inhuman, degrading treatment. There are a certain few that can never be derogated from. And so there's always, of course, the concern of countries exploiting a crisis and suspending human rights. But yes, that concept is there. Brian articulated it well. With respect to the free speech issue, it's a huge problem. I mean, we see it certainly within the U.S. The U.S. Supreme Court is right now contemplating these sorts of issues, given that, as you referred to, social media, right, are sort of this public forum. And so to what extent can governments require social media actors to do certain things? To what extent do social media companies bear responsibility for human rights violations? I've often talked with my class at great length, for example, the role and responsibility of Meta, Facebook, for the genocide of the Rohingya, where they had a role in which they amplified discourse and posts calling for violence and death to the groups. So I don't have a good answer. I mean, that is really being wrestled with at I think all state levels and at an international human rights level.
Sarah, anything you would like to add on either of those two
No,
topics? No, great.
No, just to echo what they said. It's the same in Canada. Yeah.
Yeah. I'm wondering if some of our students have any questions. They're all on Meta.
I don't think they are.
Nobody else has one.
I have a final one.
First, thanks for being with us. Thank you. I'm just thinking now politically and socially, as you look across the world, what are the common denominators of the societies that degrade human rights, especially the treatment of children? You know, you can turn the TV on, and all we see oftentimes is these terrible scenes of children suffering all over the world. And you say to myself, who the hell is allowing this to happen? Is it these strong men that take over countries? Is it tribalism or racism? Is it just people who run countries that only care about the rich and powerful? What do you see are the common threads of the challenge that we face?
I'm going to be brief because I think my colleagues have a lot to offer on this from on the ground. I would say, as we look across the different countries, it ranges from censorship, that governments can control what's being said and what kind of information is shared. But also, I think more importantly, is a lack of respect of human dignity, that in these different countries that there's just not a sense that all people in that country and elsewhere possess this quality of dignity. And tied to that, I think, is racism, xenophobia. So,
Yeah, I'm going to let Sarah.
Sarah?
Yeah, I think Brian sort of hit it on the head. I think with a lot of the common threads that we've seen, I'm just thinking about the context of the areas in which I work, largely thinking about Africa. I think for a lot of them it is sort of legacies of colonization and sort of the inability to overcome divisive issues like xenophobia and racism. There are struggles over resources that are leading and driving a lot of these conflicts. And unfortunately, children get caught in the middle. And another common thread that I've observed is also the unwillingness to actually, implement domestically any constitutional rights. I think of countries, including my ancestral home of Eritrea, where there is no working constitution. So there really is a case of a strong man in power who is unwilling to domesticate in any way the conception of human rights. And again, children who are the most vulnerable people in our society just get caught in the middle, and there's an inability domestically because of these strong men that are in place, and even internationally to try to, I mean, of course, there are a number of restrictions that would be in place. It would prohibit it, but even internationally, there is a lack of pressure, whether it be through economic or diplomatic means, that could try to change the course of what's taking place in a number of these countries. So unfortunately, yeah, we're just in this terrible situation in a lot of countries where all of these various factors are just compounding the already dire situation of some very vulnerable people.
Any thoughts? No. Well, to conclude, I kind of want to go back to. Oh, great! Thank you, Steve.
First of all, I want to say I really appreciate the effort of this panel, because it was clearly an unfair question to ask such a big question of you. And you guys have done an outstanding job. But I'd like to ask you one question that's, I think it's very troubling, because it doesn't seem that you get elected in any country because you promote human rights. You know, we see that in, across the globe right now. And kind of you see nationalism trumping human rights. I mean, no pun intended, by the way. And so I have a question. Professor Gran, you seem to have developed a rather quantitative, analytical approach to assessing human rights and impacting human rights. And the question is, the data that you create or the data that you uncover, how is it used in the State Department, or how can it be used to promote human rights such that voters, in Hungary or the United States or Russia would be motivated to say, we've got to do something? And Avi and Sarah, what about Canada? What about the United States? I mean, how do you get people to think, I have to look at this when I make a decision in the voting box?
I'll start. Great question. And tied to one of the earlier questions around free speech, a danger also is the real challenge of misinformation and disinformation. That information can be used in a way that was not intended, and that's true for indicators of human rights. I had a slide that presents a bivariate correlation that makes it look like incorporation of the UN Convention on the Rights of the Child doesn't lead to a positive outcome for children when it comes to education. That's not true. But it does raise the question of how to use these kinds of data. I see, and I know I need to wind up, primarily uses arguments, but it's just one picture, part of the picture of when governments make arguments about the importance. The other point about, in a sense, using them as arguments against governments, like Hungary. It's a big challenge, and it's an example of where academics actually need to speak out beyond universities and use what we do, our scholarship, to try to have an impact. I actually visited Hungary, gave a talk in September, and that was something that they were actually really struggling with. The national government was trying to change this national academy, and they were basically trying to censor what the National Academy does, because the National Academy had published and spoken out in ways with data, evidence, in ways that the government didn't like.
Sarah, do you have any thoughts?
Yeah, I mean, I think that's also a very interesting challenge that we've been presented with. And I mean, I think if we think about our political process, talking about something that seems very intangible, like human rights, while having very real impact on people's lives, seems like a very intangible concept when folks are really concerned about how they're going to get food on their table, how they're going to pay their rent, the rising costs of living. And so it's just not sexy politically to really talk about that. And when I'm thinking about our own sort of domestic elections, and because it seems like such a far off concept, and I think for the most part people are living lives where the direct impacts of human rights are not as visible, that it really does not become something that is on the agenda for politicians as they're campaigning. It'll be interesting to see going forward with changes now and sort of this sort of as we're transitioning out of the pandemic, as what's happening in the Middle East seems to be on the minds of a lot of people right now. It'll be very interesting to see if some of that really has an effect in the next elections. Now, Canada likely won't have an election this year. We'll have to have one in 2025. So I'll be very curious to see how some of those considerations around human rights, whether or not they actually do have an impact on the election.
Yeah, I mean, it's a great question, Steve. I mean, I think, it's really disquieting, to say the least, right, in terms of, I think, where international commitments can be framed and can be exploited by populist instincts and tendencies. Maybe somewhat naively, I guess I still am drawn to notions of incentivizing compliance with human rights, tethering it to whether it's trade partnerships contingent on human rights compliance and the like, membership in certain bodies, right, whether it's the EU, right, sort of requiring compliance with human rights, then being consistent and faithful to that and kicking out states if they're not complying. One interesting thing, right, I alluded to at the beginning, the Biden administration rejoined the Human Rights Council, but at least one of the objections that the Trump administration, I think, fairly lodged against that body was, and this is one of the challenges of a universal human rights system, is you're going to have bad actors who are party or are helping decide things. And so, should there be more stringently imposed standards for membership in certain bodies and things like that? I mean, that's one aspect. I don't know. I'm not going to actually say I hold a lot of confidence for it. There's obviously subjectivity. There are the geopolitics of naming and shaming that we see that all states, I think, are complicit in at some level or another. So there are challenges. It's God knows it's imperfect, but I think we do have to keep doing the work.
So on that note, that's my segue to my brief attempt at pulling this all together and going back to where I started, which is 1948 and the Universal Declaration. And what I often tell people that come to me wanting to know about, does the United Nations and does this international human rights architecture even make a difference, right? And there's a lot of questions. There are a lot of things that compliance has been very uneven at best globally. But when I think back at 1948, I mean, here they had to spell out that you have the right to not be arbitrarily detained. And I'm sure that 1948, when they thought, they didn't think that we would one day have a convention on the rights of children and that child labor would now be globally unacceptable as a norm. And so my final 30-second question to all three of our panelists is, the future of human rights? Like, what's the next area that we need to focus on, and what area do you think the U.S. and Canada, respectively, would focus on? And Sarah, we'll start with you, and wondering if it'll be better regulation for businesses.
I mean, I think, of course, I was going to say that is the area that I think really needs to be addressed. And then the other would be climate change. I mean, we are in a climate emergency, and I think addressing it through a human rights lens could be a way that we really combat the climate crisis and do our best to reverse it.
Avi?
Yeah, I would certainly echo that. I mean, climate change is where it's at. There was just last week a really significant decision by the European Court of Human Rights, finding that Switzerland had not met its obligations to reduce climate change. I think that is where, and you're seeing the intersection of human rights claims articulated in the role and obligations with respect to the environment. So I think we're going to have to see more actions there. And I guess that is one where you actually saw sort of some of those incremental initially just sort of aspirational, non-binding principles that sort of an accretion of binding norms and commitments. And so I don't think we have time for that, at times, slow process. Maybe we need to have, as Dean Scharf has talked about, another Grotian moment, if it hasn't yet happened, where we see those obligations and states really acting on them.
Brian, final thoughts?
Sure. One last, and I thoroughly agree. And it was a follow-up point to the first question. I'm very interested in people using courts here in the United States and Canada to bring lawsuits against businesses for violations of environmental rights, human rights, like in Montana.
Great. Well, I hope this broad conversation set up the conversation for the conference for the rest of the day. I hope you can join me in thanking our panelists for their time and their insights this morning.